Since 1907, Minnesota veterans have been afforded preference by law in public employment. Let's take a look at administering veterans' preference in local government. Qualified veterans have many preferences under the law and as such must be afforded certain benefits from the date of hire. So why give veterans preference? To facilitate the transition of veterans from the military to civilian life and to help compensate veterans for their sacrifices, including their sacrifices of health and time to the community, state, and nation. For public employers, the Minnesota Veterans Preference Act, or VPA, grants preference and protection to qualified veterans in two ways. First, in hiring preference, and second, in removal only for incompetency or misconduct. We'll explore each in more detail. The Minnesota Veterans Preference Act grants most veterans a limited preference over non-veterans in hiring and promotion for most positions in public agencies. Veterans applying for an open competitive position with a Minnesota county, city, school district, or other political subdivision who receive a passing rating may choose to receive a credit of 10 extra points. Veterans with a service-connected disability who receive a passing rating may choose to receive a credit of 15 extra points. Spouses of deceased veterans or disabled veterans who cannot qualify because of their disability may also choose to receive extra points. Once minimum qualifications are met, disabled veterans are ranked ahead of veterans who are ranked ahead of non-veterans. For Minnesota state and local government positions, no veteran who has completed an initial hiring probationary period shall be removed from the position or employment except for incompetency or misconduct. Removal requires a hearing and due notice in writing. A veteran facing removal must choose either a veteran's preference hearing or the collective bargaining grievance procedure, but not both. So who is a veteran? For purposes of the law, a veteran is a citizen of the United States or resident alien separated under honorable conditions from any branch of the U.S. Armed Forces. Qualified veterans include those who, after serving on active duty for 181 consecutive days, or by reason of disability incurred while serving on active duty, or who've met the minimum active duty required by the federal rule. The federal rule says minimum active duty is defined as the shorter of the following two periods: 24 months of continuous active duty, or a full period in which the person was called or ordered to active duty. Or finally, who has certain active military service credited under federal law. World War service in particular groups such as women, Air Force service pilots, merchant marines, and so on. Who is not covered? Certain positions and individuals in exempted situations have been excluded from the Veterans Preference Act. An agency may require employees, including veterans, to complete an initial probationary period. Probationary periods are defined to be no less than 30 days, but not to exceed 2 years of full-time equivalent service. However, after serving an initial probationary period, a veteran would not be subject to any additional probationary periods, such as for promotion or new assignment. The statute excludes department heads from veterans' preference removal rights and procedures, so agencies are not required to give notice, a hearing, or continue to pay department heads. However, an individual is only considered a department head when the individual is in charge of the work done by the department, the work requires technical professional training, the individual is in the highest authority at the level of government as to his or her official duties, the employee supervises all the work of the department, the success of the department depends on his or her technique, the employees of the department are under her direction, the employee's duties are more than merely different from other employees, and the employee has the power to hire and fire subordinates. In general, this definition of department head is narrowly construed by the courts, and any doubt will be resolved in favor of the veteran's entitlement to rights under the statute. Agencies are also not required to provide preference points to temporary or seasonal employees. The same discussion of temporary employees applies to termination decisions as well. However, use caution when defining temporary appointments, especially for temporary employees the agency rehires annually. A veteran is removed from his or her position of employment when the effect of the employer's action is to make it unlikely or improbable that the individual will return to the job. A veteran cannot be suspended without pay while the city determines whether or not to terminate his or her employment. However, the agency may suspend a veteran with pay in this situation. The law does permit unpaid disciplinary suspension in cases where the suspension is not connected to immediate termination. This action would not be considered removal under the Act, and thus no veterans' preference hearing rights exist. In other words, generally, disciplinary suspensions not leading to discharge will not invoke the notice and hearing provisions of the Veterans Preference Act. A demotion to a lower rank or grade or to a lower type of position constitutes removal under the Act. However, an employer can reclassify a veteran's position without being considered a demotion. In general, an agency may lay off or demote a veteran in situations where the veteran is the least senior employee and the veteran's position is abolished. The job duties of the veteran cannot be assigned to other, less senior positions, as this implies that the position was abolished in order to avoid the veteran's rights. To determine if the position being eliminated is in good faith, the agency needs to ask, are the job duties actually eliminated or just being reassigned? If the duties are being reassigned, are they reassigned to another non-veteran employee with less seniority than the veteran? And finally, is the position being abolished in good faith or for a legitimate purpose or as a strategy to terminate the veteran? Finally, a veteran is protected under the Act when terminated from employment. Veterans may be terminated for incompetency or misconduct under the law. Courts have held that there's no significant difference between incompetence or misconduct standard and the just cause standard in most collective bargaining agreements. A veteran must be given written notice of the employer's intent to terminate or discharge of his or her rights under the Act. Notice requirements are strictly enforced. According to the law, an agency planning to terminate a veteran from employment must notify the veteran of the intent to dismiss. The termination notice must state the statutory grounds, meaning misconduct or incompetence, for the proposed termination or demotion, the factual basis for the proposed termination or demotion, that the employee may have the right to request a hearing within 30 days receipt of the notice, that if the employee fails to request a hearing within the 30-day period, the employee's right to a hearing and other legal remedies will be waived, and that any hearing requested will be before an arbitrator or the agency's civil service board or commission or a merit authority. An agency's failure to provide a discharged veteran of this notice indefinitely extends the 30-day period for requesting the hearing. The agency must continue to pay wages until one of the following occurs. The veteran fails to respond by the end of the 30 days after having received written notice of his or her right to appeal. The veteran responds to the notice stating that he or she does not want a hearing. A settlement agreement is worked out between the agency and the veteran in which the veteran waives his or her right to a hearing. And finally, the hearing is held and a decision is rendered upholding the termination. An agency should attempt to schedule the hearing as soon as possible after notice of the veteran's request. The agency is responsible for paying all costs of the hearing with the exception of the veteran's attorney's fees, as well as the continued wages of the veteran during this 30-day period and the hearing process if one is requested. In agencies with an established civil service board or commission or merit system authority, the veteran may elect to have a hearing before the civil service board or commission or merit system authority or before an arbitrator. If no such civil service board or commission or merit system is in place, the appeal will be heard by an arbitrator. If the veteran fails to identify the election, the agency may select the hearing body. The decision of the hearing board or arbitrator must be made in writing and must include findings of fact and conclusions of law. Either party may appeal the hearing's findings to the district court. The initial results, however, are likely to be upheld unless the appealing party can show the hearing board or arbitrator abused its discretion in some way. Willful disregard of veterans' preference laws may constitute a misdemeanor by the agency. An aggrieved veteran can also petition the Commissioner of Veterans Affairs for relief. Under the law, a wrongfully discharged veteran is entitled to compensation. Even if the discharge is upheld, the veteran is entitled to compensation through a hearing process until the decision is made. If reinstated, a veteran may be entitled to back pay and benefits.